You all know there's a sign-up sheet, right? So make sure you all sign in. I'm going to pass it around starting here. Just move it around in an orderly fashion. The last person to sign in, please bring it down to me. Okay, for those of you that don't know me, my name is Joe Damry. I teach in the business department, and I usually teach the law-related courses. I've been asked to just give a brief presentation on what you can expect when you go out to apply for a job and how your future prospective employers will do a background check and how you'll be surprised at how some of the things you did in the past that you thought were insignificant might actually come back to haunt you. And the idea is for you right now, while you still have time, to clean some of those things up. And as soon as I get this to work. All right. Now, were you all able to find on my on the website on Blackboard the readings that we had? For me, it's just a journal entry. After you get done here, listening to me and reading those short articles, it's not really an assignment, but you're expected to make a journal entry. It does not have to be real specific or personal, but it does have to indicate that you went back through your Facebook pages, cleaned some things up, etc., etc. All right? So that what you've done in preparation of the background checks that are sure to come. All right? And as I said, it's a journal entry, not necessarily an assignment, but it is required that you do it. They will be checking to make sure you did. Okay? The topic, by the way, for me is integrity, responsibility, and diligence. I prefer to call it haunted by the past. Oh yeah. Some things for you to know if you've ever been involved in the legal system. Unfortunately, the legal system sometimes is not efficient. And although you might think what your involvement was inconsequential, you might find that it could be a roadblock to future employment. The first, if you have a misdemeanor or felony conviction from your youth, if you were less than 19, then in all likelihood you were adjudicated a youthful offender. It's called being a YO. If your lawyer didn't fully explain to you what that meant, I'll do so now. What that means is that your conviction was replaced by a youthful offender adjudication, so that you no longer have, in the eyes of the law, a criminal conviction. So, if that is the case, your record should have been sealed, and which means that they should not show up on a background check. Furthermore, employers are not allowed to ask if you've ever been arrested. They're only allowed to ask you if you've ever been convicted. If you have a youthful offender adjudication, then the answer to that question is no. So if any of you have a youthful offender in your past, and you have to answer that question, you can honestly say no, you have not been convicted of a crime. But I would recommend that you contact your attorney at the time and go back and make sure that the court records were done properly. A second thing, if you were arrested, you remember that you were fingerprinted. If that arrest did not lead to a conviction, then the court was supposed to send a sealing order to Albany and further direct that those fingerprints be expunged. As I told you, the courts are not always efficient. Unfortunately, a lot of courts don't do that. So some of you might have been arrested, you were fingerprinted, but then you received what's called an adjournment in contemplation of dismissal. Go out and do some community service, pay some restitution, and we'll give you an adjournment in contemplation of dismissal, which means that the charges would be adjourned for 6 months, and after 6 months, if you don't have any further involvement with the law, then the charges will be dismissed. And after the 6 months, the court is supposed to send the order into Albany that expunges those fingerprints and seals that file so that it would not show up on a background check. I can tell you that that does not always work. So I would recommend, while you have time, that you go back and make sure that that was done. I'm actually dealing with somebody right now who was arrested in 1984, and the case was adjourned in contemplation of dismissal. The judge did not do it right. This person is making an application that requires a background check, and his application is being delayed because that arrest is still showing up. It's not supposed to still be showing up, but it is. So really, you have, in my opinion, you would be wise, if you're in this situation, that you go back and make sure that it was all taken care of. All right? That's number one. Number two, again, and remember, if you have a youthful offender adjudication, remember that means you do not have a criminal record. So remember how you can answer that question. The other thing are unlawful possession of alcohol charges, and especially unlawful possession of marijuana. They're relatively minor. They don't even carry a jail term. In New York, we consider ourselves to have decriminalized possession of marijuana, at least in small amounts. That's New York. In the eyes of the federal government, if you're convicted of unlawful possession of marijuana, even if it's just a joint, you are guilty of a felony. A lot of people do not understand that the federal government, they have drug laws as well. And even though under New York law these are considered very minor, under federal law they are considered very serious. The reason that should concern you are twofold. If when you apply for financial aid, and they get to the part where they ask you, have you ever been convicted of a drug-related offense? And you say yes. And they find out about unlawful possession of marijuana. You know who underwrites the financial aid system, right? The federal government. So in the eyes of those people that are processing your financial aid request, you have committed a felony. And you could very well be disqualified from receiving financial aid. It's very important to avoid that conviction. For some of you, it might be too late. For the rest of you, be careful. And the last thing you want to do is just plead guilty to it. Try to get the court to let you do some community service and have an ACD. The other thing is when they do background checks for jobs with the federal government. Having this on your record could very well disqualify you for employment with the federal government. Now, if you sit here and you say, well, that doesn't matter to me, I don't ever intend to apply for a job with the federal government. You've got to remember that the federal government contracts out a lot of their work. If you work, say, for Corning, and Corning requires a federal contract, which they have, then you will have to go through a federal background check in order to work for Corning. For the simple reason is they work on federal contracts. And it will include drug testing, and it will include a background check. My secretary's husband was a mason, and he belonged to a mason's union. And he was assigned to work on a job at the Corning Inc. facility. Because Corning Inc. had a number of federal contracts, he had to go through a background check, and he had to go through drug testing, even though he was never going to step foot inside the building. And they're so extensive, by the way. He has hair like mine. When they did the drug test, they insisted on taking chest hairs so they could get a real history of what, if any, drug use he had. So, even if you intend to be in the private sector, you got to know, if you don't know by now, the federal government is everywhere. And even if you're in the private sector, the bottom line is this: they are certainly not going to jeopardize a government contract because of you. They're going to let you go. It's as simple as that. All right, your credit history. Credit history is relative because your employers will look into your credit history. There's a whole lot of reasons why. One, they want to see if you're financially responsible. The other reason is they want to make sure you're trustworthy. If you have a poor credit history, then that's an indication that you are susceptible to being tempted into stealing from them. Or you might be susceptible to bribery. The bottom line is they'll pick somebody else instead of you. So if you have problems with your credit history, the time to start cleaning it up is now. Okay, privacy. Privacy. There's a number of things that young people encounter when they go out applying for a job. In my day, which was the 70s and 80s, it was absolutely routine that if you went to interview for a job and you got through the first round and they were considering hiring you, you would have to take drug tests and lie detector tests. That's not so anymore. The law has changed. As a general rule, a prospective employer cannot condition your employment on taking a lie detector test. In addition, they cannot condition your employment on taking a drug test. But there are exceptions, and the exceptions have to do with business necessity. If you work in a job, for example, if you work in a job for the government that requires a security clearance, then you not only will have to take a lie detector test and a drug test before you can go to work, but they usually administer these tests a couple times a year. But in the private sector, unless there's a business necessity, you should not be subjected to those. What is a business necessity? Anybody tell me? Yes, Andrew. Yeah, but why would the job require that you have to show the boss that you're not under the influence of drugs? Liability, exactly. If you're working around machinery, or you're working in a job that is considered dangerous, then your employer is allowed to subject you to drug testing. The reason is that they have a right to protect themselves so that they don't have employees that are under the influence of drugs or alcohol operating their machinery and constituting a danger to themselves as well as a danger to their fellow workers. All right, so there has to be a business necessity. For lie detector tests, I'll give you an example of where lie detector tests were allowed because of a business necessity. A bank realized that somebody in the bank, an employee, was embezzling money. They called the police, and after the police investigated it and confirmed it was an inside job, then the bank was allowed, under the law, to require every employee to submit to a lie detector test on the grounds that it was a business necessity. So when the employer can justify the need for either a lie detector test or a drug test, then they can legally administer those on the grounds that it's a business necessity. Now your emails. When you work for somebody and you're using their equipment, there is no such thing as privacy. One thing you have to understand, you hear a lot about the right to privacy nowadays, especially because of the Patriot Act. A lot of people are really upset because a lot of municipalities are posting security cameras on every street corner. They don't like the idea that somebody is filming them as they walk down the street, and they claim it's an invasion of their privacy. People that make that claim really do not understand the law of privacy. The bottom line is this: you do not have a right of privacy unless you have a reasonable expectation of privacy. If you are in a situation where you do not have an expectation of privacy, then you have no right of privacy. Does everybody understand that? So when you're walking down the street, do you really have a reasonable expectation of privacy? Because you realize that people driving by can see you, people walking by can see you, people looking out windows can see you. So to claim that it's an invasion of your privacy, to monitor you in that situation, is just contrary to the law. You have to have a reasonable expectation of privacy. I go into a department store, and there's cameras all around, and I pick up some pants and shirts that I want to try on. As I'm walking through the aisle and going to the dressing room, do I have an expectation of privacy? And the answer is no. Once I walk into the dressing room and I'm going to drop my drawers, do I have a reasonable expectation of privacy? And the answer is yes. And so that store can film me and monitor me all they want when I walk around. But once I walk into a place where there's a reasonable expectation of privacy, like a men's room or a changing room, then I have a right to privacy. And they cannot monitor you. All right, so you always got to keep that in mind. That gets thrown around a lot, that that's a violation of our right to privacy, and most of the time people don't know what they're talking about. When you use your employer's computer, when you're at work and you're sending emails to your friends on the company computer, is it reasonable to expect privacy on those emails? Even if you're sending them out of your own personal email account. You know, it's one thing if you use your boss's email account, the company email account. But what if I log into my Joe Damrath Hotmail account and I send some emails here from school, but I'm using the school server and I'm using the school computer? Do I have an expectation of privacy? And the answer is no. The courts have ruled you do not. A very interesting case that happened up in New England where a police officer got in a little bit of jam. And the reason he got into a jam because he was texting on a police-issued cell phone. Here's the facts. So that the police officers could be more readily available, they had more privacy in their dispatches. You know, everybody's got those, what do you call them when they monitor police radios? Yeah, you know how some people have that, so they want to listen to it. Scanners, yeah. Some people have scanners, and they listen to the police talk to each other. With the advent of cell phones, the police are doing more texting and things now because they don't want things on the scanner. And so there's one police department that actually issued cell phones to all of their police officers. And they also told their police officers that you can use these for your personal use as well. But just don't overdo it. There's one particular police officer who was married, developed a relationship with a woman in the city, and one day they were trying to get his attention because there was a robbery he had to respond to, and he wasn't responding. And it caused quite a problem because I guess had the police been there in a timely fashion, they could have prevented a lot of wrongdoing that eventually occurred because the police did not respond in a timely fashion. He came under a lot of scrutiny. His authorities searched his cell phone and found that he was actually at his girlfriend's apartment on duty, and he was otherwise occupied and didn't hear the text or read the text. He was fired from his job. He sued the city, claiming that it was a wrongful discharge because they violated his privacy without a warrant by going through his cell phone. The case made it all the way up to the United States Supreme Court. And this is a couple years ago. And the court ruled and established the law that when you use company equipment, you have no expectation of privacy. Even if, as in this case, you're allowed to use the equipment for your own personal use. So even though I get on my computer here at school and I take care of some private things on my personal email account, that does not give me a right of privacy. And Alfred State College could come in right now. Bill Schultz could go right up to my office, seize my computer, and look for whatever he wants. And I cannot object because I do not have a expectation of privacy. All right? There's been a lot of litigation. A lot of people have lost their jobs because they have accessed websites they shouldn't be accessing. I can tell you this, we have, I'm the city court judge in Cornell, and we have computers down there. And I know a lot of the judges, most of us are not very good with our computers. And it's only the judges and the chief clerk that have internet access. The rest of the clerks do not. For the very reason is they don't want people surfing the internet and shopping and all this when they're supposed to be working. So we judges are allowed to do it. They monitor our email. And some of my colleagues have actually been disciplined because they've been using those computers to access gambling sites. Some of them even would come in like at 9 o'clock at night and gamble and thought that their defense was they weren't doing it during working hours. That didn't wash. The determination still was, even though it was after working hours, that they were misusing state equipment. And there's absolutely no expectation of privacy. All right. Social media. Facebook. Oh my God. We had a student here at Alfred State College a number of years ago who had an opportunity to do an internship at a pretty prestigious organization. And we got a call from that organization because they started their background check. And the first thing they did was check this student's Facebook account and Twitter account. And it was full of garbage, vulgarities, hints at drug use, hints at a party life, and in some instances, absolutely no doubt what the references were to. The organization decided they would not take the student. Your employers, your prospective employers, will check your Facebook page. determined from your postings and all those things that you're not the fine upstanding citizen you presented to them, they won't hire you. Now, you've heard about this before, right? Okay, here's the other thing. Sometimes people are working and they get frustrated with their boss. And they get home at night and they post on Twitter or Facebook, they vent about the company or they vent about their boss and say unkind things about them. And then a couple of days later, they get called into Human Resources and they're told they're fired for their expressions of dissatisfaction with the company and with the boss. And their immediate response always is, I've got the freedom of speech. You can't fire me for something I said. This has been litigated by the courts, and the courts have ruled that when you get on a public forum and you bash your boss and you bash your company, you have violated the employee's fiduciary duty of being loyal to your employer. And therefore you can be fired. You have no right of free expression. You can say what you want, but there will be consequences. So, a word to the wise. Remember that when you work for someone, you are considered an agent and you have a fiduciary duty of loyalty to your employer. Do not vent your frustrations publicly about your work, because they can fire you for it. You know, if you got a vent, say it to your best friend or your spouse or whatever. Don't post it on Facebook. If you get fired, it's all legal. Okay, what time is it? Yes!
Now, is there something you could do, like say you were convicted of something when you were younger, and it could be on Google, it could be just pages down, but still employers could see it. Is there something, I think there's something you could do where you could like hire someone, would it be a lawyer to get rid of
because
that?
what you really need is you need somebody to go to the court and have them file that sealing order. If you were young...
Or if you weren't convicted, I should say. Not convicted.
If you weren't convicted?
If you weren't convicted.
Well, if you weren't convicted,
it was
the fingerprints should have been expunged.
But if it's still on Google, like if it's still on like a report.
That's because it sounds like the court did not file the sealing order.
Okay.
And you should go, you probably need a lawyer to do it because you won't know what they asked for. If you know what they asked for, that's fine. But you really need somebody to go to the court and get that filed. The court should have done it.
Okay.
But that's my point, they don't always do it. And you really want to check that out now. This person I'm telling you about was absolutely astounded that something that happened in 1984 is still on. So you want to make sure it was done right. You know, I'm a part of the court system, but I have to admit, we're not always as efficient as we should be. And frankly, I don't think they'll have much problem, because once they realize they didn't do something that they should have done, I would think they would hop right on and do it.
And that's something you can't do, like you have to do through a lawyer?
No, because it's got to be signed by the judge and the clerk.
So you couldn't just go to the court?
Oh, you could, yeah, but you can't file the order, the court can do that. But yeah, you can go and ask them to do it. Any other questions? Have I gone over my time? What time is it? Oh my God. All right. Well, don't forget you do have to make a journal entry. All right, very good.